The courtroom display halted on the aerial photo of a dead-end street, while the county assessor highlighted a specific outline with a crimson beam. The magistrate narrowed his eyes at the diagram from his elevated seat and spoke to me straightforwardly. "Mr. Mercer," he intoned deliberately, "is that the structure under contention?" I bent toward the mic, striving to maintain composure in my tone. "No, sir," I responded. "That's the HOA leader's backyard pool." A wave of chuckles spread across the observers, then hushed as the assessor struck the display once more with his indicator. "The highlighted zone pertains to Lot 19, he clarified. "Mr. Mercer's lot." The magistrate shifted his gaze from the diagram to the HOA representatives, then to Monica Ellison, head of Silver Crest Meadows, HOA, who abruptly appeared as if she just recalled leaving a pie baking unattended for nearly a month. "So, allow me to confirm my grasp of this," the judge stated, his words deliberate and precise. "Your group initiated this litigation alleging Mr. Mercer's recent outbuilding is constructed on your territory." He switched to the assessor's follow-up display, a vivid chart where 3 residences and the shared facility were positioned cleanly within a prominent scarlet border marked Lot 19, Proprietor Mercer. Yet based on all official records and the impartial assessment, it seems several HOA dwellings and your facility are located on his land. Monica's lawyer coughed uneasily. "Sir, there has to be an error in the calculations or the documentation," he uttered, with urgency seeping into his speech. "An error exists," the judge concurred. "And it originated roughly 2 decades back when somebody sketched some highly imaginative boundary lines." I settled into my seat, crossed my arms on the desk before me, and exerted maximum effort to suppress a grin. Half a year prior, they had instructed me to relocate my outbuilding from what they deemed their territory, or face its destruction. Now, the HOA was discovering that, from a legal standpoint, they were the party that had erected a whole community in the incorrect spot. Prior to my existence turning into Alan Yu's inspired nightmare, I led a fairly uncomplicated life. I was a reserved fellow who enjoyed vintage vehicles and preferred solitude. At age 38, I had at last broken free from rental confines and neighbor dispute notes to acquire what I truly desired. 10 rugged acres on the outskirts of Willowcrest, equipped with a drooping homestead, a partially ruined outhouse, and a row of oak trees delineating the rear limit like twisted guardians on duty. Beyond those oaks loomed Silver Crest Meadows, a housing development that had strived intensely to mimic rural existence. They featured a rock entrance marker, matching contemporary rustic-style homes, and lawns so consistently verdant they seemed bound by formal agreement. The advertisement for my plot included one enchanting phrase that captivated me regarding the estate: "No HOA designated rural." I marked it doubly with my fluorescent pen to confirm its authenticity. I worked as a repairman professionally, a refurbisher by passion. My aspiration was elegantly straightforward: renovate the homestead, construct a sturdy outbuilding, and devote my evening stottinkering with the classic '72 Ford amid subpar audio shows. I hired a certified assessor to trace the boundary lines before finalizing, had the markers driven into the soil, endorsed every document at the escrow firm, exited with the title and the confidence of someone who had verified all details repeatedly. During my initial 7 days on the acreage, I encountered her. A pristine BMW crossover cruised up my gravel path, halting a cautious 5 feet away from any grime that could soil its finish. Emerged Monica Ellison, in platform heels, a jacket, and the aura of a lady who forwards duplicates of her grievances to the divine. "Hello," she greeted with artificial warmth. "I'm Monica, chairperson of the Silver Crest Meadows Homeowners Association." I cleaned my palms on my pants and inclined my head. "I'm Eli," I stated plainly, "not part of the HOA." Her grin faltered like a system glitch. "Oh, we'll address that," she remarked, with an inflection that unsettled my gut. "Our neighborhood documents describe these fields as integral to the Silver Crest ambience. We maintain precise standards for the vicinity." She presented a folder so voluminous it might deflect a projectile. "Silver Crest Meadows Neighborhood Aesthetics and Building Consistency Regulations," the front proclaimed in prominent script. I returned it immediately without perusing. No, thanks, I replied evenly. District regulations indicate I'm independent, not yours. She fluttered her lids gradually, like a lizard plotting its advance. We'll communicate further, she declared icily. I hadn't yet realized that when Monica uttered "we'll communicate further," it constituted her form of judicial warning. My outbuilding originated as a doodle on a restaurant serviette. 40 by 60 feet, metal edifice, overhead entrances, sufficient room to service triple automobiles, and stockpile wood like a scavenger with the hardware store tab. I obtained all requisite approvals from the district. The district construction office approved everything. Cement mixers arrived initially, followed bimtal shipments. By the third week, the skeleton stood erect, observable from the Silver Crest perspective, as if a fresh peak had materialized abruptly. That's when the correspondences began. The initial arrived in a shiny packet resembling a nuptial summons. Infraction alert. It stated atop, edifice observable from Silver Crest Meadows borders in an authorized hue and design motif. Beneath that, in heavy print, it asserted, as neighboring communal terrain. This outbuilding must adhere to Silver Crest criteria. I responded with precisely one line. I am not in your HOA. Cease mailing me. The subsequent missive was markedly less cordial. Pursuant to Clause 4.3 of Silver Crest agreements, all external structures visible from Silver Crest access routes necessitate design board examination and sanction. Non-adherence could lead to judicial proceedings and elimination of inconsistent edifices. I affixed that to my fridge with a clip for amusement. Then a gentleman bearing a notepad materialized at my driveway's perimeter one dawn. Neighborhood overseer, he proclaimed with contrived power, displaying an emblem that appeared duplicated at a print center. We've received grievances concerning an unsanctioned outbuilding intruding on Silver Crest Green Zone terrain. I rested on my spade and regarded him. Green zone? I inquired. The alleged overseer gestured ambiguously toward the vegetation strip past my barrier. Shared space upheld by the HOA, he affirmed boldly. Your edifice abutting it. I'm erecting on the foundation my assessor designated, I declared resolutely. On my terrain. The individual jotted a note on his pad. Our records indicate the HOA perimeter here, he stated, presenting a sealed chart lacking proportion. No formal depiction, merely a large amber circle tagged our terrain in whimsical typeface. 7 days on, a vivid tangerine placard emerged, fastened to one of my barrier uprights. Halt construction directive from Silver Crest Meadows, HOA, it announced. I removed it, carried it to my incineration drum, and consigned it to flames. Then arrived the message that intensified matters. Following multiple alerts, your edifice is deemed partly on Silver Crest HOA shared zone. You are directed to eliminate the intruding segment within a month, or the group will seek judicial solutions, encompassing raising and reimbursement of expenses. It bore Monica Ellison's signature, chairperson. I relayed the message to the district construction office promptly. They answered in 60 minutes. You're fully compliant. They lack authority over your estate. For additional steps, consult a lawyer. The term lack authority ought to have concluded it. Rather, it prompted Monica to escalate drastically. A month afterward, a document deliverer appeared at my partially completed outbuilding with a hefty bundle of forms. Silver Crest Meadows HOA against Mercer, Eli. The title proclaimed, Claim for Intrusion, Disturbance, and Breach of Neighborhood Norms. They were litigating to compel me to shift my outbuilding from what they labeled an HOA shared zone, and cover their legal costs to boot. That evening, I positioned myself at my dining surface with the litigation, my prior assessment papers, and a substantial mug of Java. I phoned my assessor, Mark Delaney, a weathered individual whose demeanor was 60% Tava and 40% disdain for imprecise diagrams. So, they believe your outbuildings on their terrain, Delaney uttered with a huff, scanning the judicial documents. That's amusing, since when I marked that boundary, their alleged green zone appeared dubiously on yours. Delaney scowled, then extracted a grimy cylinder of antique diagrams from his vehicle. Let's go and settle some folks, he stated, with a smirk. The follow-up assessment wasn't a leisurely stroll with a tape measure and notepad. Delaney arrived with the complete expert arsenal: satellite positioning device, measurement stand, Ferris locator for unearthing ancient edge indicators subterranean, and a duplicate of the initial housing layout for Silver Crest Meadows, obtained from the district vaults like a primordial judicial hex. We commenced at my established estate. Edges, located the aged steel rods precisely as expected, verified all title specifics, figures, orientations, spans, and all aligned flawlessly. I endeavored not to dwell excessively on the litigation, insisting I dismantle my semi-constructed aspiration outbuilding. Then Delaney traversed the barrier into Silver Crest domain. "What are you up to?" a runner insisted, decelerating to a wary pace as she observed our efforts. "Locating the true estate boundary," Delaney replied concisely, driving a fresh assessment marker into the earth. It was positioned well, 15 feet within what Silver Crest termed their groomed green zone. Delaney scowled profoundly, then traced another perimeter line, then one more. The additional survey markers he placed with vibrant banners, the more discrepancies emerged. At a minimum for the HOA, the authentic field layout for Silver Crest, it emerged, outlined the housing area, commencing from an edge indicator that subsisted solely in the builder's fantasy. Whoever had composed the housing diagram 20 years prior had regarded my southwestern estate edge as though it were approximately 60 feet northward of its genuine position in actuality. The whole housing development layout was displaced. On documentation, their landscaped buffer aligned flawlessly with my barrier. In truth, per the district grid markers and the historic ranch assessment from generations past, Silver Crest's buffer zone and the rear sections of multiple properties, encompassing Monica's residence and the HOA's shared facility, rested firmly on what I rightfully possessed. Delaney gazed at the assessment findings and emitted a soft exclamation. "Well, I'll be," he muttered, wagging his head. "They constructed a full HOA on your soil. Their entire back boundary is utterly incorrect. This isn't intrusion from your outbuilding. This is 2 decades of folks acting as if a flawed sketch is binding truth." He compiled a comprehensive expert dossier. Vintage ranch title, fresh assessment, contrast to the filed Silver Crest blueprint display images depicting rear decks and play equipment, merrily inhabiting my territory sans consent. I delivered the complete bundle directly to a genuine lawyer. Lawyer Park was petite, subdued, sported spectacles, and possessed the deadly precision of a medical blade. She perused Delaney's dossier doubly, then glanced up at me. "They initiated litigation against you initially," she uttered gradually. "That was deeply imprudent on their side. Besides responding to the HOA's suit, she lodged a counter-suit for me to affirm ownership, in my benefit over the contested band for intrusion and unfair gain versus the HOA and any property holders utilizing my territory sans approval, for a mandate barring them from altering my outbuilding." The genuine pivotal moment arrived when the magistrate examined all the submissions and, rather than automatically endorsing the HOA's grievances, mandated an impartial, court-designated assessment to confirm all details. "If Mr. Mercer's specialist is accurate," the magistrate stated at the initial preliminary session, looking over his bifocals at Monica's counsel group, "the organization is in a highly vulnerable judicial stance." Monica sneered from her position. "Our builder collaborated with the top assessors on hand," she declared, with total assurance. The magistrate inclined his head deliberately. "I'm certain they excelled at slideshow displays," he remarked sarcastically. "We'll allow the genuine evidence to resolve this matter," and with that, the HOA's assured progression toward what they termed outbuilding raising date transformed into an anxious hobble toward the inquiry of, "Oh, what precisely did we erect upon?" The court-designated assessor, a fellow named Diaz, was among those individuals who communicated solely in dimensions and timelines. 3 weeks on, his formal dossier struck the court record like a fallen weight. It validated every precise measure of Delaney's efforts. My title and historic ranch assessment were coherent and properly linked to district grid edges. The Silver Crest blueprint's binding depiction was evidently erroneous. The alleged communal buffer zone and rear segments of 6 dwelling properties overlapped my lot by spans from 8 to 22 feet. The HOA facility, the rear fourth of the whole structure, encompassing the storage space, bathrooms, and segment of the deck, rested solidly on my territory. Diaz incorporated delightful hue-coded illustrations in his dossier. My lot in crimson, HOA properties in azure, the intersection in luminous amber that virtually radiated from the sheet in the judicial chambers prior to the concluding session. The magistrate leafed through the amber accentuated parts. At this juncture, he declared gravely, "I'm less worried about Mr. Mercer's outbuilding and much more troubled that the organization constructed communal features on terrain they don't rightfully hold, then litigated the true holder regarding it." Monica's lawyer attempted frantically to redirect the debate. "Sir, any intersection is trivial at worst," he contended. "The outbuilding yet assaults the design essence of the neighborhood and breaches the essence of the community pax." The magistrate interrupted him. "The outbuilding is wholly on Mr. Mercer's terrain. That reality is no longer contested, which renders your intrusion allegation, and I'm being kind here, inventive at most." He shifted to Lawyer Park. "Mr. Mercer's counter-allegations are appearing more robust by the instant." Monica's expression solidified into a facade of scarcely restrained fury. "We're merely attempting to safeguard estate worth," she uttered with a strained tone. "Folks acquired residences here with the logical anticipation of a specific level. They don't wish to gaze from their panes at some unsightly steel outbuilding. They also acquired houses that are somewhat situated on another person's binding lot," Lawyer Park stated serenely, extending her palms. "Mr. Mercer has been remarkably tolerant considering the situation." The magistrate arranged a complete proof session, cautioning both parties that if they couldn't attain a resolution, he was entirely ready to rule on various key matters. Whether the HOA and intruding property holders owed me recompense for years of unapproved utilization. Whether I could rightfully insist on the elimination of edifices presently positioned on my terrain. Whether the HOA had misused the judicial procedure by litigating with ill intent. News spread rapidly in Silver Crest. Rear barrier chatter evolved into an entrance alarm in mere days. "Hold on, our deck is on whose terrain?" one resident queried in dismay. "What does intrusion signify in real currency?" another fretted. "Can he rightfully compel us to relocate the shared swimming area?" Monica attempted to convene an extraordinary HOA gathering to unite all into a cohesive stance. It proceeded poorly in every way. "Why didn't you verify the boundary lines before litigating him?" one irate resident insisted amid the gathering. "We assumed he wouldn't contest it," Monica retorted sharply, then promptly grasped she had voiced the unspoken portion aloud before 50 observers. By the moment we returned to the judiciary for the concluding session, Silver Crest had a less cohesive stance and more disgruntled patrons comprehending theft guarantee doesn't encompass disastrous folly. The proof session seemed less like a land use conflict and more like a broadcast recording off "This is your judicial outcome." Lawyer Park systematically summoned Delaney to testify. Then Diaz's dimensions charted diagrams reciprocism on aerial photography. The intersection zones shone on the judicial display like a marker blemish that refused to fade. Then arrived the genuinely entertaining segment, the messages. "Miss Ellison," Lawyer Park uttered, presenting a voluminous folder. "This is a message you dispatched to the council 3 months before litigating Mr. Mercer. Is that accurate?" On the display appeared Monica's communication in her personal phrasing. "We must proceed swiftly on this. If we permit him to complete that outbuilding, it'll be far tougher to compel him away from what we've consistently regarded as our buffer zone. People won't recognize the binding distinction regardless." "By what you've consistently regarded as your buffer zone?" Lawyer Park inquired meticulously. "You intended the band of terrain that, as we now understand from 3 distinct assessments, pertains wholly to Mr. Mercer." Monica fidgeted restlessly in her position. "That's not how I would express it if I composed that message now," she uttered feebly. "How would you express litigating a man over an edifice that isn't on your territory?" Park persisted, "while your facility's restroom is actually draining on his." The judicial observers chuckled. The magistrate did not grin, but his gaze plainly indicated he desired to. Monica's lawyer tried frantically to preserve some respect. "We suggest a fair access resolution, sir," he declared officially. "The existing state has persisted harmoniously for numerous years. Compelling individuals to actually shift edifices would be excessively severe. We can merely oblige Mr. Mercer to provide enduringus, and all can advance." "Oblige," the magistrate echoed, his inflection keen. "You litigatedayinshim for intrusion," insisted he relocate his outbuilding, warned of razing and economic devastation. "And now, you request this judiciary to oblige him to adjust for you on terrain he rightfully holds." Lawyer Park intervened, her tone impeccably courteous, but deadly. "Mr. Mercer is not aiming to displace households from their dwellings, sir," she declared distinctly, "but he is certainly qualified to select what occurs on his terrain. If the organization desires accesses for the edifices they erected without consent, they can bargain to purchase them at a reasonable market price and provide recompense for the years of unapproved utilization, and the whole will cover his judicial expenses completely." Ultimately, the magistrate's directive was harsh in all the manners Monica merited. The HOA's litigation was rejected with bias, as evidently unfounded, and initiated with ill intent. My ownership of the contested band was affirmed, signifying nobody could ever feign it wasn't mine any longer. The HOA and the holders of the intersecting properties were directed to either bargain compensatuses and utilization pacts with me within half a year or eliminate any segments off buildings intruding on my property within 18 months. The HOA was directed to repay my judicial charges and assessment expenses fully, which amounted to slightly above $43,000, and then arrived the concluding flourish atop. For objectives of organization, administration, the magistrate appended, gazing straight at Monica, Silvercrest Meadows may not exert any power or enforce any stipulation on Mr. Mercer's lot henceforth. Any efforts to do so may constitute a basis for penalties and judicial disdain. Interpretation: they didn't merely forfeit the matter, they forfeited any illusion of ever directing me again, judicially imposed. The discussions subsequently were a work of art in ironic equity. Monica had to remain there in a neutral meeting space while Lawyer Park serenely specified rates. Yearly terrain utilization charges for the bands beneath each rear yard. A one-time disbursement from the HOA for the section beneath the facility. A distinct, marginally elevated charge tagged site safeguard packed for the building that assured they would never again complain about my steel edifice. By the moment we concluded, my outbuilding finalization, homestead fixes, and a fresh automobile hoist for my workshop were totally funded by the same HOA that had attempted to overpower me into compliance. Monica endorsed the resolution pact like she was inscribing her own departure note. 2 weeks on, at an urgent HOA gathering, the dwellers elected her out as chairperson by a ratio of 47-3. She positio nersifult the lectern, her visage reddened with embarrassment and ire as Greg, a fatigued-appearing fellow, was elected in as her successor. His initial formal declaration as chairperson was straightforward. No additional litigant. No additional extensions onto terrain we don't possess. No additional presumptions. Examine the genuine diagrams or remain silent. Monica departed the gathering in utter quiet, proceeded to her pristine BMW, and motored off. She never participated in another HOA gathering. The overall monetary harm to her individually amid judicial charges, the resolution, and her share of the facility access amounted to $68,000. Almost depleting her reserves, she attempted to enlist in another HOA council in an adjacent housing development. Half a year later, their oversight firm conducted a routine history review, observed the judicial directive and the penalties, and courteously recommended she undertake a lasting period of repose from neighborhood guidance.